G'day everybody and welcome to week 8 of Laws 12063 Advanced Statutory Interpretation and Drafting. I'm Anthony Marinac. This week we get on to the good stuff. We're going to have a go at starting to draft a statute of our very own. We're going to start this week by looking at what we call the operative sections of the statute. Now, most of you will be vaguely familiar with the idea of operative sections of a statute, even though you might never have pulled them apart and conceived of them in those terms before. The operative section, simply put, is the bit of the statute that gets stuff done. This is the heart of the statute. And so by the end of today, you'll be in a position to identify the operative sections of a statute and to draft them yourself. Our actual objectives this week is first to look at some different characteristics of an operative section. We'll look at the difference between an operative section that establishes a right, one that establishes an obligation, and one that establishes a prohibition. We'll look at how we identify whom the provision is to apply and the circumstances under which it's to apply. We'll look at the difference between criminal and civil operative provisions. And then we'll look at statutory powers and how operative provisions can grant a statutory power and place conditions around it. Finally, we'll focus on the criminal law and look at whether an offence provision contains a mental ingredient. And then we'll look at the process of what we do to review operative provisions once we've drawn them. So let's start. What actually is an operative section? Well, the operative section is the core provision of a piece of legislation. These are the hooks upon which the rest of the legislation hang. These are the guts of it. They tell us what must or must not happen as a result of the legislation. They tell us what people must do or what they must refrain from doing in order for the legislation to go ahead and be successful. Now, the operative provisions might only occupy a relatively small part of the overall piece of legislation, but they are the heart of it, and every other aspect of the legislation is really only there to support those operative provisions, to give flesh to the operative provisions and help the operative provisions to actually come true. Now, before we start drafting an operative provision, there's a few things we need to think about. The first is that operative provisions come in three fundamental types, and we've come across these already earlier in the semester when we were looking at the different types of mischief. Back then we looked at a mischief that is preventing something bad or managing a risk or extending a benefit. What you'll find is that those different types of mischief line up pretty well with the three fundamental types of operative provision. The first type of operative provision is characterized by the use of the word may. These provisions extend a right. They say you may do something. Now, what makes this a right? What makes it a right is the fact that you can choose whether to do it or not. So, you may park your car in any car parking space which is vacant and not next to the curb that's marked yellow. Does it say that if you see a car parking space that's vacant and not marked yellow, you have to park there? Well, no, it might be nowhere near where you want to go. You can keep driving if you like. But if you want to, you can park there. You have a discretion, you have a right. So a may provision extends a right. The second type of provision imposes an obligation. This is a provision that says you must do this. You have no choice. When you turn 18, you must register to vote. If you don't, there may be consequences for you not doing so. So you can see the difference between a provision that's imposing an obligation and a provision that's extending a right. The final type is must not. A must not imposes a prohibition. So a provision including the word must imposes an obligation to positively do something. A provision using the term must not imposes an obligation to positively not do something. You must not. You are prohibited from doing it. So we have a prohibition on stealing that says you must not steal. You don't have any discretion about it. What you'll find is that virtually all operative provisions in virtually all legislation that you've ever come across fits fairly neatly into one of those three fundamental types. Almost all operative provisions extend a right, or they impose an obligation, or they impose a prohibition. Now let's make it a little bit more complicated than that. On many occasions, the right, the obligation, or the prohibition, which is established by a piece of legislation, is then modified by a set of conditions. Those conditions can usually be described using the words if or unless. And sometimes those conditions, sometimes there's more than one condition, and they can add up on top of one another. If you add those conditions, you get what I refer to as the 12 basic models of operative provisions. Now I've reflected them graphically there on the slide, but to me I think they make more sense in the way that I've reflected them in the notes, where I've written them out in words. Let's go through them. The first 4 of the 12 basic provisions are obligations. So the first one is you must do whatever the requirement is. Second is you must do the requirement if a condition applies. The third is you must do the requirement unless a defence is in place. The fourth is you must do the requirement if the condition applies unless the defence is in place. So you can see how we can build conditions on to one another. The second 4 follow exactly the same model, but they refer to rights. So you may do the exercise of a right. You may do the exercise of a right if a condition is present. You may do the exercise of a right unless a restriction is present. And you may do the exercise of a right if a condition is present unless a restriction is present. And then the final 4 go through exactly the same pattern with the words must. You must not do a prohibition. You must not do a prohibition if a condition is present. You must not do a prohibition unless a condition is present. And you must not do a prohibition if a condition is present unless a condition is present. Alright, now I'm willing to bet that some of you are scratching your head at the moment and saying to yourselves, this sounds like nonsense. Utter nonsense. Probably a fair call in a way, but I'm going to try and bring it all together now and make it sensible. And once you've listened to this next little bit, you may want to go back and listen to the start of the lecture again and see how much more sense it makes now that I've given you the final context. What I want to do is go through those 12 basic models of operative provisions, and I want to use them in a practical example. It's the practical example that I've given in the notes, so you can read along and have a look at it yourself. Let's imagine for a moment we're parents and we're setting some rules for our kids. We're going to set 12 different rules for our kids, or for one of our kids, and each of those rules is going to follow a different one of the 12 basic models. The first 4 rules are must provisions. The first one is a simple must provision. You must clean up your room in the morning. The second one is a must provision, so it's an obligation, but it has a condition. You must take out the rubbish bin if it is full. The third one is a requirement, so an obligation with a defense attached. You must do your homework unless it is the weekend. And the fourth is an obligation with a condition and an exception or defense. You must fold the washing if any is waiting, unless it needs to be ironed. So you can see those keywords must, if, and unless prescribe the obligation and the conditions surrounding that obligation. The second group of 4 obligations, or second group of 4 rules, are going to be rights. The first one is simple. You may read a book at bedtime. The second one has a condition. You may play games on the computer if your homework is complete. The third one has a restriction. You may walk down to the shops with your friends unless it is dark. The fourth one has both a condition and a restriction. You may go outside to play if it is light, unless it is raining. I'm hoping that by now you can start to see that all of these provisions, all of these model provisions, really do make sense and allow us to impose obligations and extend rights, and to surround those with conditions to make sure that they're only used in the appropriate circumstances. The final 4 relate to prohibitions. The first one is simple. You must not tell your mother lies. The second one includes a condition. You must not turn the dishwasher on if someone is using the shower. The third one creates an exception. You must not shout inside the house unless there is an emergency. And the final one includes both a condition and an exception. You must not go into your sister's room if the door is closed unless she invites you in. You can see that by using the key operative term, must, may, or must not, and then the terms if and unless to impose conditions, we really do have a flexible tool to describe virtually all of the types of operative provision we could ever need to put into a piece of statute. It's pretty amazing if you now take that system of models and go and pick pretty much any statute at random, find its operative provisions. You're going to be able to look at those and see just how well they fit in to this basic model of 12 types that I've given you in this lecture. When we write statute, the first thing we're going to do when we're designing an operative provision is start thinking about which of these 12 models the operative provisions are going to follow. Now, unless you've got a fair idea of those 12 provisions and how they work, the rest of the lecture is not going to make much sense. If you're still struggling a little bit with the idea of that set of 12 models, I would really encourage you to go back and listen again, or I'd really encourage you to pull open the written notes and see how I've presented the written notes before you go onwards. From this point forward, I'm going to assume a pretty sound understanding of that basic model of operative provisions. We're now going to get drafting, and we've got a set of instructions from a public service department. Those instructions read as follows. Consultation with student groups has indicated that one of the key reasons for students exiting tertiary education without completing their degrees is the cost of obtaining necessary technology. Whereas in the past students could successfully complete their courses of study with little more than pens and paper, it is now necessary for students to have access to computing and often mobile computing technology. The government has decided that an annual grant will be made available to students to enable them to purchase technology. However, eligibility will be restricted to students who are at a university studying for a bachelor's degree or higher, and the grant will be restricted to students with an annual income of less than $30,000. Please ensure that there are appropriate mechanisms to punish anyone who improperly tries to get a grant, and mechanisms to enable us to recover funds which should not have been paid. We are not yet entirely certain what the amount of the grant will be, and it may change from year to year. Please draft the operative provisions and forward them to us for review. Alright, how are we going to write these operative provisions? First thing we're going to do is have a close look at the instructions. What are the things that the legislation we're about to write will have to make happen? What are the basic, fundamental, heart things that must be done? The core provisions that must be there? To me, there's three. The first one says students may apply for a grant. We're not going to force students to apply for a grant. It's something that they're going to have the capacity to do if they wish to. So it's a right rather than being an obligation. Second thing we're going to have to do is impose a prohibition. We're going to have to say students must not lie about their circumstances in the application. And the third thing we're going to have to do is impose an obligation on the public service department to say, if you've got a valid application, you must pay. Now, if you think about it, those three operative provisions on their own provide the basic structure that we need for this legislation. Students may apply, they must not tell lies in their application, and if their application meets the criteria, the Secretary of the Department must cause the grant to be paid. So now that we've got a basic idea in the back of our minds as to what the provisions should look like, let's go ahead and start planning our operative provisions. The first thing we're going to have to think about is who is the subject. Now, when we talked about grammar, we referred to the subject as the person, or as being the person, the object, or the concept which is doing the verb. Now, if the verb in an operative provision is the thing that is the right or the obligation or the prohibition, then the subject will be the person who's actually bound by the legislation. The subject will be the person who has the right, or the person who has the obligation, or the person who must not do whatever is prohibited. So the very first thing we have to do when we're establishing new statute is work out who is the subject. What are the characteristics of the subject? Now we know that we're going to have three provisions. The first two, the subject will be the student. So it's the student who's going to have the right to put in an application, and it's going to be the student who's prohibited from lying in their application. What do we mean by a student? Well, our instructions tell us. The first thing we need to think about is the fact that they must be at a university. The second thing we need to think about is that they must be studying for a bachelor's degree or higher. So a bachelor's degree, a graduate certificate, a graduate diploma, a master's degree, or a doctorate. So those are the characteristics that we need to have for the subject being the students, for our first two operative provisions. For the third operative provision, we need somebody in the government. In this case, most likely the secretary responsible for tertiary education. For those of you unfamiliar with the public service, a secretary is the very senior public servant. The equivalent title in the Queensland government is Director General. They basically are the head of the public service department. So that's the person who's going to have responsibility for managing the payment of grants. So we can see we're going to have three operative provisions. Two of them will apply to students, one of them will apply to the government, and we've now started to work out exactly how we're going to define the people who will be bound by the operative provisions of this legislation. If you don't get the subject right, then you're not going to have good legislation. Imagine, for instance, if we went ahead and drafted this legislation and we just referred to students. Well, wouldn't that mean TAFE students could put their hand up for the grant? Wouldn't that mean that students at high school could put their hand up for the grant? Wouldn't that mean that students taking a private art class one night a week, or students taking ballroom dancing lessons, or students taking karate lessons could also put their hand up for this grant? You see the importance of making sure that we define our subject very carefully. Having done so, we can then go on and reconsider what the legal effect is going to be. So in relation to each of these subjects that we've identified, are we extending them a right? Are we binding them with an obligation, or are we binding them with a prohibition? So you can see on the slide there, we've identified students, we've identified the government, and now we're saying for the students they may apply for a grant. That's not going to be mandatory, but if they do, they must be truthful in their applications, and that is mandatory. From the government's perspective, we've identified the secretary as being the subject, and we're saying they must pay grant money to eligible students, and that's mandatory. So that's an obligation. So you can see what we're doing now is using those 12 basic models of legislation to start building up our operative provision. The third step starts to look at whether or not there are additional circumstances. And this is where in the basic models of legislation we would be using the words if or unless. We're going to start with physical circumstances. Now those are circumstances outside the subject's mind. In this case, one of the circumstances that is going to apply to students is that their tax return from last year must show a taxable income of $30,000 or less, because that's how we're going to demonstrate that they have a sufficiently low income that they should be eligible for the grant. So we're now really changing our provision a little bit, aren't we? Because we're saying students may apply for a grant, they must be truthful in the application, and then we're saying the secretary must pay the grant money to students whose tax return shows a taxable income of $30,000 or less. So we've now taken the group of students to whom this is going to apply, and we've narrowed it down even further in accordance with the instructions that we received at the very start. The next thing we've got to consider, now that we've considered physical circumstances, is mental circumstances. This one's a little bit more complicated. In many cases, mental circumstances won't apply, but in particular in criminal provisions, we will always be thinking about whether the mental circumstance, what the mental circumstances are for an offender. You see, criminal offences take on different characteristics depending on whether the actions of the offender were intentional, reckless, or negligent. In addition, you may remember the concept of a strict liability offence. Now, a strict liability offence is an offence regardless of whether the person was reckless or intentional in their conduct. So you don't need to have fault elements for a strict liability offence, but a strict liability offence can be defeated if the person who committed the offence was under a mistake of fact. That is, that they believed that the facts of the circumstances were such that they were not committing an offence. So we need to start thinking about, if we're creating a criminal offence which will usually arise from a prohibition, and even if we're creating an offence which is not a criminal offence, what state of mind do we expect people to be in order to find them to have committed that offence? Now, we know that we've said that people must be truthful in their applications. Students applying for this grant must be truthful in their applications. What I'm suggesting is that that should be a matter of strict liability. So even if they are not deliberately lying, or even if they are not reckless as to whether they're telling the truth or not, if it turns out that they have not told the truth in their application, there should be consequences. At the very least, recovery of the grant money. Best way to do this is to make it a strict liability offence, and then if there was a mistake of fact and the student has made a valid mistake, they're going to be able to make that argument in their own defence. Finally, wherever we're imposing an obligation or a prohibition, we need to think about what the consequences should be if the person does not comply with that obligation, or if the person does not keep themselves within the prohibition. There are a number of different types of consequences we can impose. One type of consequence might simply be the loss of a right. So it might be that a student who was not truthful in their application would not have the right to get a grant, even if it turned out that they were otherwise entitled. We might impose consequences in terms of penalty units. Now, a penalty unit is a pecuniary penalty, a financial penalty. In Queensland at the moment, a penalty unit equates to about $110. We might say that if a prohibition was not abided by, or if an obligation was not performed, that some other person, particularly someone who suffers as a result, might have an entitlement to compensation. Finally, for criminal offences, we might look at the full range of criminal punishments up to and including imprisonment. Now, once we've done that, once we've thought about all of those things, who is the subject for each of those provisions? What is the legal effect of each of those provisions? What are the physical and mental circumstances that should surround each of those provisions? And what are the consequences that should occur if the provisions are not abided by? Then we can get on and actually draft up the statute. And you'll see in the notes for this week that I've gone ahead and done exactly that. And the way those three operative provisions turn out reads as follows. The first section is headed up, "A student may apply for student support grant." A student may apply for a student support grant if A. the student is enrolled in a degree program at a higher education institution, and B. the student's taxable income for the previous financial year was less than $30,000. Now, to understand that, you have to refer back to a definitions section which I've created, which defines both higher education institution, degree program, and taxable income. The second provision says the Secretary must cause the student to be paid a student support grant if the student has applied for a grant and if the student meets the conditions. The third provision is an offence provision that says a student must not submit an application for a student support grant containing false information, and there's a penalty of 5 penalty units. Now, the process of getting there is much more complicated than I'm going to be able to set out in the course of an oral lecture, and the material that we're looking at doesn't readily lend itself to being described orally. I guess what I've provided you in the last 10 or 15 minutes is a little bit of a commentary to the process, but there's not going to be any substitute for sitting down with the lecture notes for this week and reading through and following the process so that you can see how I've arrived at the operative provisions that I have arrived at. What you're going to do now is have a go for yourself, and when you do have a go for yourself, it will make a lot of this stuff make much more sense. So what are your instructions? Your instructions read as follows. It says, despite years of effort and millions of dollars, Australian children remain among the world's most obese. They are addicted to junk food. The best efforts of schools and health authorities are being undermined by the apathy of parents who simply don't care enough about their children to ensure that they have healthy nutrition. We have decided to act on this by compelling parents with criminal sanctions to send their children to school with adequate and nutritious lunches. Please draft operative provisions which would make it an offence to send a child to school with no lunch or with a lunch containing junk food. We're not entirely sure how we should define junk food. Come up with something and we'll look at it as a starter. We would also like to make it a much more serious offence to send children to school with a lunch containing more than trace amounts of peanuts. Finally, we want teachers to be under an obligation to report to their principal any student who they notice with no lunch or with a non-complying lunch. Now at this stage, all I want you to do is draft the operative provisions. Don't go trying to draft the entire Act. We'll think about that next week. What are the operative provisions that need to be identified for the instructions that I've just read out there to take place? To whom will those operative provisions apply? How do we define the subject sufficiently in each case? What's the nature of each operative provision? Is it a right, an obligation, or a prohibition? What are the physical circumstances that apply? Do those physical circumstances, do those conditions best fall under the use of the word if or unless in terms of the 12 basic models of operative provision that we've talked about earlier today? If we're creating an offence, what mental circumstances are going to apply? Will it be enough merely that the facts have occurred, or are we looking for intention and recklessness? Finally, if there is an offence provision, what are the consequences if people get it wrong? Once you've done that, once you've written those provisions, think again about some of the stuff that we talked about a couple of weeks ago in terms of proofreading. Stick it in the deep freeze. Set your drafting aside, whether it's a few hours, a day, or a week. Then pull it out again and attack your own drafting. Imagine for a moment that you've got a client who's been charged under these provisions, or you've got a client who's missed out on a benefit because of these provisions, and you're going to argue against them. What loopholes can you find? What problems can you find with the definition? What arguments would you make if you were trying to undermine that legislation? If you read your own writing aggressively in that way, you'll start to see what needs to be fixed or clarified in order to make your provision stick. Now, before we finish up today, I want to speak briefly about statutory grants of power. Statutory grants of power are a form of operative provision that still fit very much within the model that we're talking about, but in them, the legislation is providing either an obligation or a right to a public servant or a public service department, and it's usually a right or an obligation that gives that department power to make decisions with respect to normal people. So it's extending a right or an obligation to make decisions. Public officials only have the ability to make decisions about normal people in their lives because statute says so. A police officer is just the same as you and me. They have no additional rights over us as a human being. However, as soon as they put their uniform on and as soon as they've got their badge out, they do have additional rights because in Queensland the Police Powers and Responsibilities Act says so. So you can see public officials only have powers because there's legislation that allows it. The legislation that allows public officials to have these powers are statutory grants of power. If you're writing a statutory grant of power, you need to think very carefully about three provisions. First, is the decision-making power mandatory or discretionary? So, if the circumstances arise for a decision to be made using this power, does the public servant have a choice? Can they simply decide not to exercise the decision-making power, or must they make a decision whenever they're asked to make a decision? Second, what are the parameters you want to place around that decision-making power? Generally speaking, the decision-making authority of a public servant is not going to be at large. They can only make the decision within certain perimeters that have been established by the legislation. Third thing is, in any jurisdiction, a statutory grant of power is going to be bound up by legislation such as the Administrative Decisions Judicial Review Act 1977 in the Commonwealth or the Judicial Review Act 1991 in Queensland. How is your new grant of statutory power going to be affected by those pieces of legislation? Now this of course requires you to drag out some of your old knowledge from administrative law, and I don't propose to reteach you all of that in this context today. But if you are drafting a statutory grant of power, remember that you are playing in the heartland of administrative law, and you're going to have to make sure that whatever statutory grant of power you make works within the context of the rest of administrative law, works within all of those rules that generally bind public officials in the exercise of power. Alright, we've moved fairly swiftly today, and as I mentioned a few minutes ago, the nature of this material that we're dealing with this week is that it works much better in written form than it does in oral form. There's no lecturing substitute for you going through step by step and following the drafting process that I've undertaken in relation to the Student Support Grants Act, and then having a go yourself in terms of the Student Lunches Act that we're going to start drafting this week and then complete drafting over the next 2 weeks. I really hope you find this to be an interesting exercise. I've always found it to be a fascinating exercise, and I look forward to continuing it on with you next week.